Good afternoon, everybody. Welcome to today's session facilitated by the IOSH Environment and Waste Management Group. I'm David Thomas, I chair the EWMG, and today's presentation is given by the legal director from Pinsent Masons LLP, Zoe Betts. Zoe has worked presentations on health and safety in our sectors for a number of years. I last came across, so I think before COVID at Leicester at a waste industry session where she was talking about some very interesting topics in health and safety topics in the sector. What I would ask at this stage before we go live is if any people present in the room wish to have a topic, wish to present, wish to offer their services to the IOSH so volunteer, please drop a line in the chat with your email or telephone conversation link so we can catch up with you. We're always looking for new ideas. If you've got a piece of work, a piece of research, anything you're doing that can contribute to the world of knowledge, we'll be happy to talk about it through EWMG. And that includes the possibilities even of a mini conference, maybe 2 or 3 presenters in an hour and a half over lunch. Anyway, notwithstanding, over to Zoe. If you wish to put your camera, upload your presentation, and I will hide my screen. I will monitor the chat. There's a Q&A session. I will feedback when I can with the Q&A. And please remember, don't put questions in the chat, and please don't put chat in the Q&A. And if you have an idea of wishing to present, give us an idea on what you would like to talk about as well. Don't just drop a note in an email. Let us know what your topic is or your area of interest is. That'd be fantastic. Zoe, the floor is yours. Enjoy.
Thank you very much, David. Lovely to see you again, and welcome to everybody who's attending this webinar today. As David said, by way of brief introduction, I'm Zoe Betts. I'm a legal director in Pinsent Masons Health and Safety and Regulatory Risk team. I've just put on this one slide here the various different topics that we deal with. Myself and my colleagues were spread across national offices in the UK, and it's quite a broad church. As you can see, we deal with all aspects of health and safety, but also thrown in is building safety and fire safety, which are 2 huge topics in their own right, and also elements of product safety and food safety. But what are we really going to be focusing on today? Well, we're going to have a fairly quick canter through issues which I've been advising on recently, which I think are of interest to you in the waste and recycling sector. I'll very briefly set the presentation into context by talking about the key risks, or the risks that I perceive to be key in your sector, and I don't think there'll be any surprises there. I'll recap the key legal duties, which of course you'll be aware of, but I think it's important just to focus on 2 things. Health and safety law imposes criminal as well as civil sanctions, and really we're focusing on the criminal aspects of the law today because that's what I am, a criminal defence solicitor. And also, of course, remembering that health and safety law imposes personal as well as corporate liability. So we need to be thinking about that as well. In terms of the hot topics, of course, we've got to think about COVID as we move from pandemic to endemic. Quite closely linked to that, an issue which I'm fairly interested in is mental health and the global ISO standard 45003. Of course, it wouldn't be a health and safety update if we didn't touch on sentencing. And very quickly at the end, I'll do a nod to some of the new technologies that are emerging and what I think that might mean for legal risk management. And of course, as David said, we can hopefully have a bit of time at the end for Q&A. So what are the key risks in the waste and recycling sector? Well, there's many, I'm afraid, and you know that. You do operate in a high hazardous industry. And I think to trot out the old phrase, it's still important that we don't shout about safety and whisper about health. There are so many potential hazards that can cause injury and potentially fatalities in the waste and recycling sector. But as right as it is to focus on those issues and to prioritise your risk control measures to reduce the likelihood of those incidents happening, we cannot forget that occupational health is a growing force. And I've certainly seen this in my defence practice, that the HSE is getting increasingly interested in and increasingly adept at investigating and prosecuting occupational health, whether it's matters to do with vibration or exposure to dust. So I think we've got to make sure that we're covering the whole range. But of course, it's right to focus on things like moving vehicles and machinery. They remain the top two causes of serious injury and death in the sector. And of course, it's right that we continue to focus on those foreseeable risks. And foreseeability is an issue that I'll come back to shortly. So what are the consequences of getting it wrong? Well, this slide is intended to look at the end of it like a bit of a migraine, and that's really because there are so many potential consequences of a serious incident or fatality. And really, this is my day job, but it's not yours. And I think that's the point, that you will realise that the time and the effort and the money and the moral consequences involved in a serious incident really ought to be avoided. Prevention is always better than cure. So if we are dealing with a serious incident giving rise to some sort of injury or ill health, we know, do we not, the world in which we live in, this is highly likely to give rise to some form of claim for compensation. And the stuff in blue is civil. So we won't really focus on that. But the point to remember is, in the chaos that follows a serious incident, and it is properly to be described as chaos, people naturally are nervous. They're very far from their comfort zone. They can do relatively simple things that have quite severe consequences, including failing to notify your insurance promptly and failing to notify them in the right way. And of course, what happens then is a very time-consuming and unnecessary wrangle with your insurance company if they don't want to pay your legal fees or a quite substantial payout. Coroner's inquest, of course, that only happens if there's been a fatality. A workplace death is unnatural and gives rise to a coroner's inquest. It is not meant to be a trial, but it will feel like one. And it is a fact-finding inquiry that takes place before the HSE have nailed their colours to the mast and decided if they are in fact going to prosecute, or very often that's the case. So these hearings have to be navigated very carefully from an evidential perspective. The stuff that we've got here in yellow is criminal liability for individuals. Now, I'm not here to overstate the position or to scaremonger. Individual liability is a fact. It would be remiss of me to say otherwise, but it is rare in comparison to corporate liability, which we'll focus on for most of this session. So yes, of course, if there is evidence that individuals have breached health and safety law in their personal capacity, they may well be prosecuted and convicted, and the sanctions for that are criminal sanctions. So it's very, very serious, but as I say, comparatively rare when we look at corporate liability. And there we're looking really at prosecutions brought under the Health and Safety at Work Act 1974, or the raft of subordinate legislation, the regulations that are introduced underneath the 74 Act. Of course, we have the Corporate Manslaughter Act if there is a fatality of sufficient gravity. But in all honesty, in my opinion, that law hasn't really done what it was meant to do since 2007. No large corporate with disparate layers of management has actually been held to account under that piece of legislation, bit of a damp squib. And with the sentencing guidelines that have increased fines significantly for offences under the Health and Safety at Work Act, I think the prosecution take a fairly pragmatic view that that's how they will take the case to court. And last but not least, in green, we have kind of slightly less tangible, but no less real consequences of a health and safety incident. And this can be, of course, adverse PR, knock-on effect to your share price, and potentially lost business or an inability to either apply for, bid for certain work, or to win certain work if an organisation has a health and safety conviction or multiple convictions, which obviously indicate a rather poor health and safety record. And I think the example I always give here is when we think back to the really tragic crash on the Smiler roller coaster at Alton Towers. I think you'll all recall that hit the tabloids and the broadsheets. And of course, it went to the very heart of that company's ethos. Merlin Attractions Limited owned Alton Towers. They make a tremendous amount of money trying to scare you to death, but they're not actually meant to kill you. It's about the thrill of the fair, but unfortunately on that occasion, the evidence suggested that thousands of people had been put at risk over many, many months, if not years. And of course, the incident itself was particularly dramatic and serious for the individuals involved. So at that time, you can't have imagined worse PR and reputational consequences for that company. So let's just cover the basics of the law, just so that we know exactly what we're talking about today. The stuff in left, or as I'm looking at it, the stuff in left, the stuff in blue, the civil liabilities is not really what we'll focus on today. But the point there is that if there has been a breach of health and safety law, which has given rise to somebody suffering bodily or psychological injury, or they've been killed, then of course their estate may want to claim. They are highly likely to claim against the company because individuals don't have deep enough pockets, quite frankly, for a financial payout of any substantial size. And for that payout and for the legal fees involved in that civil claim, so long as your insurance is valid and is responding, generally the insurance company will cover the cost of that entire action. But of course, there has to be some sort of bodily injury or psychological injury. There's got to be harm for there to be compensation. And why am I making that point? Because it is different when we look at the criminal side of health and safety law, and that's the stuff in red. That's what we're really talking about today. I don't think people necessarily realise this because a lot of health and safety cases quite naturally follow serious incidents where people were injured or killed. But that is not the offence. The offence in health and safety law crystallises when the defendant, when the duty holder creates a material risk to somebody's health and safety and doesn't guard against that risk by taking reasonably practicable steps, generally. That is generally what the law says. There are certain examples of strict liability offences in health and safety law, which are not qualified by reasonable practicability. If something happens, for example, access to dangerous parts, that is the offence to which there is no defence. Generally, we'll come on to look at the Health and Safety at Work Act and the notion of reasonable practicability, but the actual offence occurs when you create the risk. And that makes sense, doesn't it? Because the health and safety executive, as we know, can come onto site, they can shut you down with a prohibition notice because what they see, in their opinion, gives rise to a serious risk to personal injury. It would be ludicrous if the HSE had to wait until that risk actually eventuated in harm before they could take action. They're not going to do that. They have the power, because the creation of the material risk is the offence, to intervene at that point. And that's why, in certain cases, a near miss, a serious near miss, but nonetheless a near miss, can be a breach of the law and can give rise to a criminal conviction. And I think the point as well to make is that insurance plays no real part in the criminal aspect of health and safety law. If you have a good, comprehensive insurance policy, it may well cover your legal fees, but it absolutely will not cover any fine imposed by the courts, because that is the punishment. On a corporate or an individual defendant, it would be against public policy for the insurance company to step in and effectively take away the defendant's punishment by paying the fine. So it has to come off the bottom line of the company, and it's generally paid within 28 days, unless there are some pretty robust submissions made to the judge who may or may not accept them on the day. So what are the duties that I'm talking about? Health and Safety at Work Act 1974, we're all very familiar with that. And, it's a long piece of law, but in fact, you only need to look at a few sections in my experience. I've been doing this for about 15 years now, and the vast majority of my cases are still investigated and prosecuted as breaches of either Section 2 and Section 3. Section 2 is the duty to ensure the health, safety and welfare of employees. Section 3 is the duty to ensure the health and safety of non-employees. And I am yet to find a case where somebody doesn't fall within the scope of either Section 2 or 3, and that's deliberate. You are either an employee because you have an employment contract with your employer, or you're not. You're some other form of worker, and there are some fairly interesting labour arrangements at the moment, but in any event, you'll be caught by Section 3 if you're an agency worker, a temporary worker, a gig worker, a contractor, a visitor, a member of the public, a child. Section 2 and Section 3 bite on employers, and it's all to do with the scope of your undertaking and the risks that arise from the business that you run. Now, it wouldn't be fair and it wouldn't be achievable if the law imposed absolute duties. If you were simply meant to ensure the health, safety and welfare of employees or the health and safety of non-employees, you would do nothing to produce anything by way of a business product. You would be following people around 24/7 trying to keep them safe, and that would be absurd. So this is where we have the qualified duty in law of reasonable practicability. And no, although I'm going to cover my own view on what reasonable practicability may involve over the next few slides, I cannot give you a definition. It is not defined in law, and that is deliberate. The Health and Safety at Work Act is a piece of goal-setting law. It creates an objective for the duty holder to achieve. You, as the company running the business, need to understand the risks that you run and how best to mitigate those risks. No one else is better placed than you to understand your own risks and the measures that need to be put in place to eliminate or reduce those risks to a lower level as possible. And so it is a duty holder decision as to what is reasonably practicable. It's not the HSE's decision. They will very often disagree, and that's why they prosecute. They say, you didn't take reasonably practicable steps. The company may say, we did. And of course, the ultimate arbiters are the jury if we end up in a Crown Court trial. So that's where these cases ultimately play out. And it is a high bar, I have to say. I've been doing criminal defence work. I started as a fraud lawyer 17 years ago, and I've been doing regulatory health and safety work for about 15 years. I've taken one case to trial on the basis that that was the case I felt could be defended on the basis of reasonable practicability. It's not that I don't want to take more cases to trial. I think of myself as a litigator, but in reality, the UK health and safety framework is so strict, and rightly so, that in the vast majority of cases, when I've truly understood the fact of the case and what gave rise to the incident or what's given rise to the prosecution, the advice has to be, you are more than likely to be convicted. It is not, therefore, the right case to take to trial. Your penalty will be higher as a result, as will your cost and the stress involved in the case. We cannot realistically demonstrate a defence of reasonable practicability. That happens in the majority of cases, but there are, as I say, one or two where you ultimately need the jury to decide if what you did was reasonably practicable. So what we have to think about is, where does reasonable practicability come from? Well, it comes from your risk assessments, and I'm sure, sorry if that's not quite the answer you wanted, or that's not very sexy, but risk assessments are the cornerstone of health and safety law. You have to understand the risks that you create in order to make a judgment about what reasonable controls you will put in place. And I say judgment because that's exactly what it is. A risk assessment is not a document. A risk assessment is a mental thought process which you ultimately reduce to writing, or the significant findings of your thought process. And you need to make sure that you have got an ability to capture your thought process. And my view on this actually is that it can sometimes be incredibly useful to record what you deemed to be not reasonable, as well as what you deem to be the reasonable controls. And those are the controls that you then brief out by way of a method statement or a safe operating procedure or some form of induction or training. Of course, that's right. The reasonable controls are the ones that are going to be put in place in the workplace. But if you are ever to be accused of not having taken a measure that was reasonably practicable, it is really useful to dig out some record, whether it's the risk assessment itself or some other associated document which says, well, hang on, back in the day when we were looking at this issue, we did consider that measure, but for these reasons, we deemed it to be unreasonable. Now, that is a wonderful place to be. That is an answer to the question, or an answer. It might not be a good answer, but it might be your answer to an allegation that you haven't done a suitable and sufficient risk assessment, or that you haven't implemented all of the reasonably practicable controls that were available to you. So that's something to consider. Risk assessments are exercises in foresight. And I think sometimes this is what's difficult in health and safety cases, where of course we all end up looking backwards with the benefit of hindsight. Well, look at this tragedy, look what's happened. What could and should have been done to prevent it? Well, on many occasions that fits and that's okay, but actually the law is based on what could you reasonably foresee when you are doing your risk assessment exercise. And we need to focus on the reasonably foreseeable risks. What I don't want is for people to get distracted sometimes about fanciful or hypothetical risks, or risks that we think of as everyday risks, walking from one place to another, carrying a drink. These are, in my view, human activities, which quite frankly, an employer doesn't necessarily need to or want to get involved in. What it does is takes your eye off the ball. We just looked at that slide for what your key risks are. Those risks have been around for decades, but they are still giving rise to serious injuries and incidents. So we're still not necessarily where we need to be in managing those risks. They are your reasonably foreseeable risks. And it is those risks that you need to concentrate on when it comes to these reasonable controls. And you are allowed to consider issues. In fact, you have to consider issues of cost. because what you're ultimately doing is some sort of equation or computation. What is the risk that we're running? And what would it cost us in time and money and resource to reduce that risk? And weighing into that balance is, well, what would be the harm that would eventuate if that risk materialised? Is it a risk of death, or is it a risk of a paper cut? Because you will clearly do more, I would suggest, to eliminate or reduce the risk of a highly serious incident versus one which would be quite unlikely to happen, even if it did, would cause minor harm. So that's the assessment that we're going through. That's the risk assessment process. And then I think the main point for me also, and this came out of a case called Polyfloor, the phrase blueprint for action. And that's lovely, really, because your risk assessment shouldn't sit in pristine condition on a shelf, or these days on a server somewhere. Your risk assessment has to be a living document. It has to give rise to some action. It has to be fed through the organisation. People sometimes get confused that the law says you have to show people your risk assessments. You don't. But what you do have to do is make sure that people understand how to work safely and how you want them to work safely. So it's really the means by which you communicate the significant findings of your risk assessment. I often see wonderful documents and then interview 5 members of staff who will immediately tell me that they don't really understand the safe system of work. So the risk assessment, that might be fine. You won't be prosecuted for lack of a risk assessment, but you will be prosecuted under section 2 or 3 because you failed to get that message out, and people are simply not working safely. So what does reasonable practicability look like in practice? Well, these are the sorts of things that I look at. This is not a definition in law, by the way, but this is the sort of thought process in a nutshell that myself and my colleagues would go through if we were looking at whether there was a viable defence in a case. So it's a non-starter if you can't demonstrate leadership and investment in health and safety from the top down. You've got to understand how health and safety is resourced and managed. Has that manifested itself in a sophisticated health and safety management system that is evidenced, that is capable of being evidenced through robust systems, policies and procedures? And do people know about those? Have you got a skilled and trained workforce? And do you have competent advice internally and or externally? No problem in relying on subcontractors so long as you've vetted them in the right way, approved them in the right way. We don't want to see a race to the bottom where we're going for the cheapest option for somebody who can get it done as quickly as possible. And of course, we need mechanisms for auditing how well we're doing, monitoring. You need leading, lagging indicators. And also I want to see that where issues have been identified, which is natural and which is good, I'd be surprised if you weren't identifying issues through a robust auditing and monitoring procedure, but please close those actions out. It is fatal to a health and safety defence if what we actually find on the documents is months and months of health and safety minutes where employees or advisors have been raising issues, timetabling actions, and nothing has been done. And I have seen that in certain cases. And not only does it mean you've got no defence, when we come to look at the sentencing guidelines, it generally means you're in high culpability because you've ignored concerns that have been raised or you've ignored previous incidents. So if we are going to have some sort of auditing and monitoring function, which you should have, please make sure it's an effective one and that we're closing out the loop. As I said before, I only did have one case on reasonable practicability that I wanted to take to trial, and it was successful. After a week at trial, HSD dropped their case into section 2 and 3 because in that case, which was a rollaway fatality in the waste industry, we had demonstrated through the evidence that there really wasn't anything more that the employer could or should have done. In simple terms, the driver was trained, the vehicle was roadworthy, there was a risk assessment and method statement for the task that was being done at the time, there was a handbrake that worked, there was a visual alarm that flashed on the dashboard. There was an audible alarm that sounded if the driver tried to exit the cab without the handbrake being applied. So in the circumstances, I think we were able to demonstrate in that case that all reasonable practicable steps had been taken. But those cases are few and far between, I have to say. So let's move on to personal liability. This gets a little bit closer to home. We've touched on section 2 and 3, which is corporate liability. But of course, as I said at the start, each individual within an organisation from the top to the very bottom will have legal duties. They may not know about it, but they are there. So all employees, shop floor upwards, have a duty under Section 7 to take reasonable care of themselves and others who may be affected by their acts or omissions at work. And believe it or not, they also have a duty to cooperate with you, the employer, insofar as matters of health and safety are concerned. And sometimes it may be worth a bit of education around this. If you have employees as a group or individually who are being particularly difficult, it may be that they simply don't realise that actually they have a legal duty. And although it is comparatively rare, of course, we've seen prosecutions and successful convictions under Section 7 for employees who have blatantly failed in their duty. Section 37, that is slightly higher up the chain of command. That is for directors and senior managers. And I think of this as a bit of a piggyback offence. So what we have here is where there is an offence committed by the company under Section 2 and 3. Of course, in reality, we all know that a company is no more than an entity, a legal structure. Of course, it has to operate through its senior individuals. So in any case, really, even brought under Section 2 and 3, you know that there is personal failure sitting behind that prosecution. But generally, the HSE are content to take the prosecution against the company, against the employer. Where they feel, and this is from their enforcement policy statement, that it is fair, justified and warranted, they may choose to prosecute one or more individuals. And where we're looking at Section 37, there's 3 limbs to that: consent, connivance or neglect. The HSE don't need to nail their colours to the mast, but it's generally fairly obvious from the evidence which of the 3 is in play, because they have slightly different meanings. Consent is really quite unusual, if I'm honest. That is one of the worst cases that you will find, because there would have to be evidence that the senior manager or the director had actual knowledge of the unsafe state of affairs and positively endorsed it, accepted it and controlled it and drove it forward. That is unusual, highly unusual and highly culpable, I'm sure you would agree. Connivance is a lovely old English word for turning a blind eye. So that's that feeling in the pit of our stomach where we know that there's something that's not quite right, but we really don't want to challenge it. We really don't want to get involved in that awkward conversation. We'd far rather go and do what we know and love and is in the comfort zone. So you just want to walk on by. Well, you can't if you're a senior manager or a director and what is going on is in any way within your sphere of authority. You have the control, you have the seniority to stop and have that conversation. And if necessary, you have the authority to direct that activity stops until you are satisfied that it's safe. To not do that is potentially falling into the connivance category. And neglect is even more tricky, shall I say, because neglect is where somebody can end up with a criminal conviction arising out of circumstances that they did not know anything about. And in fact, I think some people have a view that not knowing about something may well afford them a defence. Well, I'm here to tell you that it absolutely won't, because neglect is an offence built into Section 37. And so if in fact some horrific accident has occurred and a defendant or a director or a senior manager thinks it will exonerate them to say, well, I knew nothing about that, the HSE will immediately come back with, but should you have known? And that is the question. What should you know about by virtue of your role, by virtue of your area of responsibility, by virtue of your authority? What should you be asking about? What should you be inquiring about? And that phrase inquiry, should you be on inquiry, is from a case called R&P Limited, which involved the death of a child. So really this is about not believing that you can sit in the ivory towers, sit in the office and count the beans. And so long as you stay away from the sharp end, you are highly likely to be protected from the force of law. In fact, it's the other way around. To be actively involved and to have a real understanding of what goes on from a health and safety perspective, and to be satisfied that the right systems and procedures are in place, that those resources have been correctly deployed, that you have the right people in the right jobs. That is the sort of action that will ultimately afford you a defence if something goes horribly wrong and you are potentially in the frame. You need to be able to demonstrate what you have done to get to that position of knowledge, but you are assured that the right things are being done. You cannot be there 24/7. This is not about standing over people's shoulders, but it is about getting involved. And I think, as I say on the slide, the people who are most vulnerable are those probably in small to medium-sized organisations who are senior managers and directors and therefore have strategic influence, and you have authority to stop work, but you're also close enough to events on the ground to have operational influence. You do actually know how this job's being done. You can't argue that you're 8 layers of management away and that you had absolutely no involvement in the way that the work was going on. The closer you are to the work, the more active you have to be in taking that reassurance that the right safety measures have been put in place. And the consequences of being convicted under Section 37 are, of course, very serious. It's a criminal conviction, it's social opprobrium, it's a fine which would have to come out of your own pocket, at worst imprisonment, but that is very, very rare. Disqualification is occasionally used. I mean, we are looking at between 20 and 40 cases a year versus 200 to 300 corporate prosecutions. But I'm not sure that's the point. I think the point is you just don't want to be one of these people. You don't want to be in this situation of having a dreadful incident occur on your watch and then somehow your acts and omissions being dragged into question and ultimately you being found in breach of the law. So it's really thinking about what can I proactively do to make sure that this isn't going to happen to me. So let's move on. That's the law, that's setting the scene. What we want to talk about now are a couple of the issues that are really quite topical and what could be more topical than COVID-19. So as at the end of February, or the 24th of February 2022, the UK government ended the legal COVID restrictions in England. Now, please be aware, I am talking about England here and I've not got time to cover the other jurisdictions, but there are subtle differences where we're talking about Wales, Scotland and Northern Ireland. So if any of those locations are of interest to you, you would need to just go and look at the different guidance that applies in those jurisdictions. And the changes follow the publication of the government's report, COVID-19 Response, Living with COVID-19. And I think that's quite an interesting title because we are living with COVID-19. We're moving from pandemic to endemic, and that can only be a good thing, but we all need to be aware of, well, what does that mean? If the legislation has been revoked, which in many cases it has, what then is left in its place? And this report by the government sets out its objective for managing COVID-19 like other respiratory illnesses, whilst also minimising the mortality rates and being ready to respond in the event that a new variant emerges, which could potentially put the NHS under unsustainable pressure once again. So examples of the changes that are included in this Living with COVID-19 report are the cessation of the self-isolation period following a positive test. That is no longer a legal requirement in England. It therefore follows that an employee would no longer have to inform their employer of a positive test or whether they are absent from work or self-isolating because of COVID-19. We also have no explicit requirement to consider COVID-19 within an employer's risk assessment. But I have to sound a note of caution here, of course, because we still have the underlying ever-present Reg 3 duty in the Management of Health and Safety at Work, Regs 1999. So I don't necessarily think that we can ignore COVID altogether. What we need to consider in risk assessments is what reasonable measures are now appropriate to further reduce the risk of transmission in the workplace. And we also have, from the 1st of April this year, updated working safely guidance. And this says that employers really need to give greater consideration, no surprise, to any worker who may be particularly vulnerable or at higher risk of serious illness. And I know there are some quite tricky HR issues, which we won't get into today, but I don't necessarily think you need to go around asking workers if they are vulnerable or trying to identify for yourself who those workers might be. I think you have to be open and encouraging to your workforce to approach you if they have concerns, and then you can decide what the appropriate next step to take is with that individual or with a group of individuals. HSE guidance, it's called Continuing to Reduce the Risk of COVID-19 Transmission in the Workplace. And this clearly highlights the fact that whilst legal restrictions have ended, you should still consider risk reduction measures in the workplace, including adequate ventilation, sufficient cleaning and good hygiene. If we keep those in place and we keep discussing the issue with employees, you are highly likely to be doing all that is needed to comply with the guidance and also to reduce the transmission in the workplace. So what does the post-COVID workplace look like? Well, I think we have all acknowledged that the world of work has changed and probably changed forever. During the COVID-19 pandemic, employees and employers were either required to work from home if they were able to do so, or they were advised to work from home if able to do so. Obviously, since the start of this year, when that work from home guidance no longer applied, we were seeing employees being allowed or even encouraged to return to work as normal, as before the pandemic. But I'm not sure that that's going to happen, to be honest. I think we have seen the potential benefits of working remotely, and it is popular with the workforce. Flexible working, what we're talking about here is either home working or hybrid working, where you split your time, changes to working hours, or changes to the times when people do their work. And there have been quite a few statistics coming from surveys, and I'm not a massive fan of statistics, although there's a few on the slides in this presentation. I think you need to approach them with care, but I think the consistent theme is that flexible working is important, it's popular, and it's here to stay. So in the top left there of the slide, that was the Adecco Group survey, and that showed that 77% of people feel the best way forward is hybrid working. We've also seen a Bright Horizons survey of 1,500 parents. No surprise, 55% preferred a mix of office-based and home working with no more than 3 days in the office. And more than 56% of those surveyed felt that increased flexibility would have a positive impact on productivity and on employee loyalty. So I think when we are considering as employers, how do we attract the best talent and how do we retain them? This issue now is much more important than it was 2, 3, 5, 10 years ago. And the government seems to support this greater flexibility and greater agility. The Welsh government in particular has acknowledged that COVID has changed the way that we work and live. They want employees to continue working remotely. They feel that there are benefits for local economies, for the individuals themselves, for the environment. There's reduced travel time, reduced cost, reduced noise, air pollution, traffic pollution. There's an ability to redesign towns and city centres, and they have a goal of 30% of Welsh workers working at or near to their home in remote working hubs. So I really do think employers now have to get to grips with this issue and manage it for the weeks, months and years that are coming ahead. ACAS, as you would expect, have issued some guidance on how employers can go about supporting workers who are engaged in hybrid working. And first and foremost, I think, is create a policy and treat people fairly. You don't want to create a two-tier system of workers for those in the office and those who aren't. And other practical issues, straying slightly into HR here, but it's obvious that you might need to update your employment contracts. You need to consider how you're going to protect confidential and sensitive data if people are taking it out of the office. Of course, you need to look at health and safety arrangements and carry out certain risk assessments. People are working in a new environment. Their new workplace, maybe their home, maybe a cafe. We've got to get our heads around what we are expecting people to do and the extent to which the employer can control that. When it comes to providing equipment, who's going to pay for it, who's going to provide it, who's going to maintain it, who's going to inspect it. These are all issues that can have a solution, but they need to be thought about in advance and laid down in some policies and procedures is my recommendation. And the HSE has also updated its home working guidance for those who work permanently at home or who split their time between a workplace and home. And again, this comes down to risk assessment. So the HSE's advice is that you don't necessarily have to take significant measures. The risks to home workers in most cases will be relatively low, but you nevertheless need a suitable and sufficient risk assessment, which should consider, amongst other things, stress and mental health issues, which can be caused by remote working, lone working, and I'll touch on that as a separate topic shortly. The use of equipment like computers and laptops, because if you are a display screen equipment user, Irrespective of whether you're doing that at home or at work, there needs to be a proper workstation assessment. And then there are other aspects of the general working environment that this guidance covers, which should really be factored into your risk assessment. And that brings me on really to the health implications of COVID, because we are not going to get away from COVID for quite some time. There are people who unfortunately suffer from what's referred to as long COVID or long tail COVID or post-COVID-19 syndrome. There is no accepted internationally recognised clinical definition, but I think we all know what we're talking about. And this is highly challenging for employers and employees. You can have people who appear to be fit enough to return to work, but then have to go off again. You can have people on long-term sick. And you need really a joined up approach, I think, between health and safety professionals and HR and maybe occupational health to deal with people in this situation. As at 31st of January of this year, it was estimated that 1.5 million people in private households in the UK are experiencing long COVID. So this is not an insignificant number of people or an insignificant population within the workforce. The ACAS guidance says that normal rules for sickness, absence and sick pay should apply, and that where an employee is absent with long COVID, an employer should try to agree how and when to make contact with that person during any absence, make sure their work is covered and shared fairly while they're off, and talk about ways to support them when they return to work, which includes discussions about communicating their illness to other people if they want that or if they don't want that. So really it's about making sure there has been an appropriate risk assessment for that person's return to work. I won't dwell on this too much because it was a relatively discrete case, but it is interesting to show that as a result of one of the 300,000 proactive COVID spot checks, there was a prosecution. This arose out of a visit in Manchester in July 2020. As I say, it was a COVID-19 spot check on a construction site. And yet, of course, when the inspector's there, they're not going to focus solely on COVID-19. They're not going to put the blinkers on. They're absolutely entitled to look at other issues. And they served a prohibition notice and 2 improvement notices in respect of a range of issues, COVID-19 breach being one of them, but also welfare issues, site security, working at height and electricity. They go back a month later, as they often will do, and unfortunately little or no improvements. So there are yet more enforcement notices served, and a prosecution naturally was instigated. On this occasion, there was a prohibition notice for an unsupported excavation. So I think what this case highlights more than anything is not so much the COVID-19 issue, it's more to do with getting the basics right, because once the HSE are on your site, they are entitled to look at other issues, and it could easily be that you find yourself falling foul of health and safety law because of a range of non-COVID-19 related issues, and that is a real own goal. Moving on, mental health and ISO standard 45003. I think this is an increasingly important area of practice for OSH professionals in recent years. It's been growing in importance. We've had a volatile economy since Brexit. We've had the COVID-19 pandemic, and I think we are simply more aware than ever that mental health is the flip side of physical health and can't really be divorced one from the other. ISO 45003 was published in June 2021. It was marketed as the first global standard giving practical guidance on managing psychological safety at work. And this built on previous reports by the government in 2017, and of course the HSE management standards going back as far as 2004. So really the question, I think, is, well, what is the real value of this ISO standard? Well, I think it's worth just looking at some health and safety statistics that I will run through very, very quickly, because these were only published in December of last year, and it's the first time we've really measured the effect of the pandemic in terms of work-related stress, depression or anxiety. And it's undeniable that the pandemic has had a negative impact on people's mental health. I think the 2 key statistics for me are these on the slide here, that cases of work-related stress, depression or anxiety rose 30% in 1 year. So new cases went from 347 to 451,000. And equally well, of those 822,000 workers suffering from a new or long-standing case, nearly 450,000 reported that it was caused or made worse by the effect of the COVID pandemic. So publication of the ISO 45003 standards is very timely in giving organisations an opportunity to consider what effective risk management might look like in this space. It's aimed at managing psychosocial risk, and I'll come back to that term shortly. And that's based on the Health and Safety Management System Standard 45001 that you will all be familiar with. According to the BSI, this new standard provides the first international definition of workplace well-being. And I quote, workplace well-being is the fulfillment of the physical, mental, social and cognitive needs and expectations of a worker related to their work. And that, I think, really gives you a sense of the scope and ambition behind this new standard. And as I say, it's introduced this new term, psychosocial risk, which I wasn't aware of before, but the standard describes that as the combination of the likelihood of occurrence of exposure to work-related hazards of a psychosocial nature and the severity of injury and ill health that can be caused by these hazards. And they break down into three categories, basically. Aspects of how your work is organised, so that's relating to roles and expectations, control and autonomy, workload and job security. Secondly, social factors at work, so interpersonal relationships, lone working, leadership, reward and recognition. And then thirdly, the work environment, equipment and hazardous tasks. And I think we all accept that historically in the waste and recycling sector, there have been examples of inadequate equipment and some poor working conditions, which naturally can give rise to these mental health issues that we all want to avoid. So what is it that employers should really be doing? I think in terms of identifying psychological or psychosocial hazards in the workplace, the standard itself gives you quite a lot of guidance. You need to have a detailed understanding of your workforce by developing quite mature and sophisticated processes for collecting relevant data and then undertaking detailed analysis. And the standard guides you through that. I think you'll need to have a multidisciplinary approach. So as I put on the slide there, employee wellbeing has traditionally been the province of HR. It's been viewed as an HR issue. But I think if you're a proactive organisation, you will want to manage psychosocial risk in a much broader way, and you'll be bringing together experts from occupational safety, HR, risk, compliance and legal, because there will be many, many different aspects to this, including, for example, data protection and the dreaded GDPR. But you will need to get a grip of all of those issues in order to implement this standard and to make real changes within your workplace. And you might say, well, is it even relevant to the waste and recycling sector? We've got other priorities. Well, I can understand that. But when I looked recently at the HSE statistics for the waste sector in 2021, they published the health and safety stats. It was clear that there are around 5,000 work-related ill health cases annually, new or long-standing. And 3/4 of those are either musculoskeletal disorders or stress, depression or anxiety. So I think it would be wrong for us to say that as a sector, this is an issue which doesn't touch us. I don't think that can be right. So I won't dwell on this too much in the time that I've got available, but you have to decide really on a cost-benefit analysis. Do we want to implement ISO 45003? It's guidance, so of course it's not compulsory. You can either choose to be accredited or not, and there's some possible incentives and some possible disincentives there. And I think I don't want to overstate the importance of this issue. I think from a moral perspective and from a productivity perspective, we all accept as occupational health professionals that mental health is really important and has probably been ignored for quite some time. From an enforcement perspective, I am not going to sit here and say that I think we are going to see a massive prosecutions. I think that will be evidentially very difficult. Because of the way RIDOR is drafted, many cases don't even get on the HSE's radar. And that is not really your biggest risk. I think your biggest risk here is not looking after your workforce and people being absent due to mental health problems, which are in some way linked to work and the workplace. And I won't put it any higher than that. Let's move on to a favourite topic, sentencing, and some of the recent fines, the big fines that we've seen in the last year or two. I'll touch in more detail on WH Malcolm and also British Airways shortly, but really this slide is just to demonstrate that we are getting chunkier and chunkier numbers coming through. We've had the guidelines since 2016. I'm not going to run through them. You will be as familiar with them as I am. You know they are based on turnover, and you know that judges are getting more and more confident in applying the guidelines. We've seen there in the National Grid case, 5 million. Oh, sorry, I've got a £5 million fine on my notes. It should say maybe £4 million fine, but that arose out of a fire and gas explosion, which sadly killed a pensioner in her home in West Yorkshire and put care home residents at risk. So all of these fines on the slide are 7-figure fines. You know, I've been doing this for long enough to know that only 6, 7, 8 years ago, it would almost have been unheard of in what we would consider to be a relatively standard health and safety case for the fine to be north of £1 million. Fatality cases were generally around the level of £500,000 because they weren't based on turnover, and because, quite frankly, the courts weren't imposing high enough fines for them to represent proper punishment. And that really is what underpins the sentencing guidelines. So let's have a little look very quickly at enforcement by the HSE. No reason to go into this in any detail. All of the trends are downwards. So we have seen over the last year far fewer prosecutions. We've seen far fewer enforcement notices, and the level of fine has dropped as well. But I think that's really indicative of the COVID-19 pandemic. It will change. We will get back to where we were pre-pandemic, I'm sure. It's simply the case that there was less work going on, and there was less ability for the HSE to get out there and do visits and identify breaches and instigate cases. And the courts had a massive backlog, as we know. But all of that is starting to get moving again. So I don't think that this will necessarily be a static picture for long. Let's have a look then at these two cases that I alluded to, British Airways PLC. First point to make really is that I'm harking back here to judgments, Whirlpool and also PFPH, which is Places for People Homes, which deal with this issue of VLO, or very large organisation. And people are interested in very large organisations, mainly because the sentencing guidelines, that's the only real area where they're so vague. We're all familiar with the tables that apply to small, micro, medium and large companies, but there is no financial threshold within the guidelines to tell us what is a very large organisation and when it may be appropriate and proportionate for the judge to move outside of the figures set out in that large table. In Whirlpool, the Court of Appeal said that the VLO status, the finances, the high turnover of the company justifies doubling the starting point of the fine. And that was a fatality case, which is important to note. That suggestion of doubling the starting point for a very large organisation was reiterated by the Court of Appeal in that recent case of Places for People Homes. That was a case that was related to vibration-related ill health. But what was interesting in that case was that the turnover of the defendant was about £298 million. In Whirlpool, the judges had suggested that the threshold for a very large organisation might be around £1 billion. So, of course, 298 million is significantly lower. And on that occasion, the defendant appealed on the basis that the sentence was manifestly excessive. They were not a very large organisation under the guidelines. Court of Appeal said, no, that's wrong. We're actually entitled, and the judge at first instance was entitled to look at your assets, of which they had about £3 billion, and also their very significant net profit. And taken together, that company was correctly deemed to be a very large organisation. In giving the judgment in that 2021 case, the Court of Appeal helpfully said that there is not, and there should not be, a bright dividing line between large and very large. So I think what that really means is they're still refusing to give us a financial threshold. They still think that it is fact sensitive on that particular case for that particular defendant. And in their words, this is not something for mechanistic extrapolation, which is a lovely phrase. So I think we're still no further on other than knowing that in any particular case, you've got to make a judgment for yourself whether you think this is or isn't, on the face of it, a very large organisation. British Airways PLC, let's have a look at the facts of that case. They're set out there on the slide. This happened in March 2018, and a female employee was seriously injured when she was pulling a tug with a train of dollies or baggage transport vehicles attached to it. She was knocked under a passing tug with dollies loaded with luggage and was crushed. The HC investigation indicated that this particularly unsafe walking route had actually been in place for about 10 years. There were other significant failings to do with supervision, monitoring and workplace transport. And BA pleaded guilty at the first opportunity to an offence under Section 2 Health and Safety at Work Act, which we looked at before, the corporate duty owed to individuals, owed to employees, I should say. The sentencing hearing wasn't straightforward. It's unusual, but it was 2 days back in May 2021, and the judge reserved judgment until June of 2021. Expert evidence was heard on behalf of both the HSE and the defence, and that could be partly because BA's turnover was so high, and therefore the stakes were so high. In 2018 and 19, the turnover was £13 billion, and in 2020 it was down to £4 billion, clearly as a result of the pandemic, but nevertheless, still a very large organisation. And the judge, in fact, said, your revenues are likely to go back to where they were pre-pandemic. I'm not taking your 2020 turnover. I'll go back to the £13 billion turnover. Thank you very much. He found BA to be at the high end of high culpability. So that is a tough decision. But on the evidence, there was a failure to implement industry standards. There were concerns raised by employees that had been ignored. There were previous incidents, but changes hadn't been made. You're virtually ticking off things in the sentencing guidelines at this point. The breaches had been subsisting for over 10 years, as I said, and it was a case of systemic failure. So this is high culpability, not very high, but high. Only saving grace maybe for the company was that the judge accepted that whilst there was a risk of level A harm, being death or very serious injury, it was a low likelihood of very serious level A harm. So that's harm category 3. And very quickly, if you just look through the points on the side, how did the judge get to the ultimate fine of £1.8 million? Well, this is where you see again the doubling of the starting point. Here, the judge found it acceptable to double the starting point because of the VLO status to £2.9 million. There wasn't any aggravating features. There weren't any aggravating features. There was mitigation, which reduced that starting point by £200,000. And then there was a third discount for the guilty plea. So that's where we get to a £1.8 million fine. But I think the point there is that there is judicial confidence in doubling a starting point of a fine to represent very large organisation status. That's fairly bold compared to where we were 12 or 24 months ago. A case that I also mentioned a couple of slides ago, highest fine to date and a particularly tragic case. They all are, of course, but when they involve a child, I think we all accept they couldn't really get any worse. And this case arose out of a death at Daventry International Rail Freight Terminal. It was a prosecution by the Office for Rail and Road rather than the HSE, but same enforcement of the law. Death of an 11-year-old boy who had easily gained access to retrieve a football, climbed on top of a stationary freight wagon which was parked underneath live overhead power lines which were electrified by 25,000 volts. The company did not plead guilty, but went to trial and was ultimately convicted of 2 offences. That Section 3 Health and Safety at Work Act offence, non-employees that we looked at the start, and also a Regulation 3 risk assessment offence. Trial lasted 3 weeks, and during that time, evidence was heard on how the company had failed to risk assess unauthorised access, even though they were aware that it happened before. They'd failed to implement appropriate measures to prevent it, and it wouldn't have cost a great deal of money to do so. And there was evidence that whilst freight trains were routinely parked underneath live equipment energised with 25,000 volts, there were unelectrified sidings where those vehicles could easily have been parked and where access could not have been gained by members of the public. As a result, the company's culpability was unsurprisingly found to be high. There were serious organisational failures to address health and safety risks. Concerns have been ignored again and again. The breaches subsisted for a long period of time. So the sentencing judge did not find it particularly difficult to find high culpability. A number of people have been exposed to the harm, and also the offence is a significant cause of harm, all factors which will push the fine up. Turnover of the company was about 185 million, so it was large under the guidelines. High culpability harm category 1 gave a range between 1.5 million and 6 million, with a starting point of 2.4 million. But the judge went back to Whirlpool, which was also, of course, a fatal case. And there he said, the fact of the death justifies a substantial move away from the starting point to the top of the category or the next one. And of course, the one above high culpability is very high culpability. That had a starting point of £4 million with a range going all the way up to £10 million. There were aggravating factors in this case. There was previous enforcement history. There were very significant effects for the witnesses, the children who'd witnessed their friend die and their families. And it was inexplicable that work for a modest sum of money had not been carried out to mitigate these risks. Yes, there were some mitigating factors as well, as you would always expect. But ultimately, of course, no reduction for a guilty plea because this matter was taken to trial. And what the judge said was that in contesting this trial, the defendant failed to take responsibility for a serious and obvious failing to allow public access to what was and is a dangerous environment, and imposed a £6.5 million fine, which is the highest to date. Lastly, and very quickly, we will just look at a couple of new technologies in safety. Understanding safety implications from new technology is part and parcel of your job as IOSH professionals. Smart technology is part and parcel of the world in which we live in. But I think what we have to ask is how smart is the technology when it comes to safety? And you'll see from the image there that the obvious example of this dilemma is smart motorway technology, where we have the hard shoulder being converted into a live running line. 38 people have died on smart motorways between 2014 and 2019, and a number of coroners who've been involved in the inquest into those deaths have raised concerns with National Highways and the government over the basic safety premise of smart motorways. So the UK government have said they will halt the introduction of further all live running smart motorways for 5 years while it gathers data on their safety. But what about other types of technology? Of course, artificial intelligence. There are many types of artificial intelligence and many bits of AI technology, I should say, that can help to improve working conditions or provide safer alternatives to completing dangerous tasks. There are some really interesting examples out there. You'll know more than me, I presume, but there's wearable technology, there's PPE compliance detection. We've all seen COVID-19 compliance, temperature testing, and that's an example of how quickly this stuff can be devised and rolled out. So it can be a useful tool to improve occupational safety and offer health benefits. But I think there are some threats and challenges and concerns that need to be explored so that workers' rights are respected and the data is protected and discrimination is avoided. The TUC in particular believes that AI risks could spiral out of control unless they were protected by stronger regulation. And I think this has become particularly contentious during the pandemic, when some people have a view that AI technology is becoming more Big Brother ish, in the sense that it's not necessarily about safety now, it's more about monitoring productivity. And people don't want to feel that they're being judged, hired or fired by an algorithm. So the TUC is pushing for 3 things, basically. Workers to have a new legal right so that a human would review a decision made by an AI algorithm. For a legal right to switch off from work, and also for employers to consult trade unions for any high risk and intrusive technology introduced into the workplace. And lastly, drone technology. According to a recent report by PwC, by 2030, the drone industry could be worth £42 billion to the UK economy. There are calls for the government to appoint a minister for drones to assume responsibility for the industry. And like AI, there are huge potential benefits to improving safety and also improving efficiency, reducing environmental impact, cutting costs for various sectors, whether it's airports, roads, infrastructure, agriculture. But what we need to do is develop the regulatory framework. And in 2021, there were a number of changes to drone usage and safety, and those are set out really in the little bubbles that you've got on the slide there. SAFED, the Safety Assessment Federation, have also issued guidance if you're interested in this issue. They explore drone technology in relation to examination and inspection of plants and machinery. So you may want to have a look at that if this is something which you're interested in for your business. I'm aware I've probably run out of time, but I am done. So thank you very much for listening. And David, if you've been monitoring the chat function, please let me know whether there's anything you'd like to ask me.
Thanks very much. You've got about about 10 minutes just under, and
Okay.
about 5 questions. So
Okay.
I'm gonna go through them rather rapidly. I don't think we can do each question justice. Each one, I think, is a debate in its own right. And
Oh, really? Gosh, okay.
I do thank those who have put the questions in. And the first one, if, as you quite rightly propose, reasonable practicability is not defined in law, will a judge always draw from case law, even in criminal proceedings?
Well, of course, it's not the judge that ultimately decides on reasonable practicability, it's the jury. If we're going for a Crown Court trial. Of course, if you're in the magistrates, you're either at the mercy of a lay bench or more commonly, you've got a district judge. But I would often suggest to my clients, if we're going for a trial, we go to the Crown Court. And I think that actually being tried by 12 members of your peers is the right way to go, because when you are looking at reasonable practicability, it is a concept, I hate to use this phrase, but you want it to be rooted in common sense. You want a variety of opinions from people who've had a variety of different jobs and backgrounds to give their own opinion on what you as an employer could or should have done. And so for me, it isn't going to be defined in law. It will be fact sensitive, and you are going to be judged by the jury, and you have to try to convince them. And this is why it's so difficult, because often these cases involve someone who's been dreadfully injured or killed, and you still have to be able to say, we don't think we could have done any more to prevent that from happening. That can seem on the face of it a very unattractive argument, but actually sometimes that is the right argument to run. If the company wants a shot at a defence, and they should be acquitted, if you genuinely think as a legal professional they really have discharged their duties in law, go for it.
And that's because the Colston trial, of course, that the deliberate decision there was to go to the jury for that reason. Because and again, the beauty of it is that was a specific case, and that's if you about case law. If there's, you know, if something else slightly different happens elsewhere, the key words are different. Is the key word? It's different, and therefore be judged on that. People might use it. I'm saying people will use other evidence, and this is where the HSE have always said, from in terms of reasonably practical for the waste sector, the previous inspectors, I think it was Paul Harvey, was saying that it was either Paul, Trevor, or Chantel, many people on the WISH forum over the years, they are looking at the WISH guidance, and the interpretation of the WISH guidance is the key thing, because that is an industry-based, what is deemed to be acceptable to industry. And we ain't about tripping over what is acceptable. So I do think that we have all the information, and as EWMG have done, we produce training for all supervisors, for local authorities to champion. It actually brings the HSE management, so brings the WISH forum guidance to life. It gets people thinking about ill health, etc., and ill health management. So yeah, that's what we were doing. Terence asked, how far down the food chain will the HSE prosecute an individual under Section 37?
Oh, good question. And I can't answer that specifically, but what I will say is don't try and be what's the word, creative with job titles, because that won't necessarily get you out of a Section 37 prosecution. People think, oh, well, we won't call anyone a director. We won't call anyone a senior manager, and then they'll never be caught by Section 37. It's not true. The evidence will be focused on what did that person do? What was the scope of their authority? What was their responsibility? And this has been argued in court. So whoever's asked that question, I forget the name, sorry, you're absolutely right that in certain cases, we will fight the Section 37, not on the basis that that senior manager didn't consent, connive, or be neglectful, but they weren't a senior manager at all. They're too low down, and they should never fall within Section 37. They should fall within Section 7, which in itself isn't always a perfect argument, because they could be prosecuted under Section 7. And the HSE can always bring the alternative, a Section 7 and a Section 37. So you're caught by one or the other. But it is always better for the individual if we can get them outside of the Section 37. But it will come down to a matter of evidence as to what their actual role involved, rather than just a title.
James Perkins made a comment about the health impact for operational staff walking 10 miles each day, whether for 15 years. And I answered one question electronically, but the question I left open is, what advice can the panel provide regarding very term health issues is the question being asked. And my comment is very much to look at ill health absence and relate that to the type of work being done. Consider it. Consider how the risks that your work creates or has, how they impact on health. And I think that's something that is encouraged. Alas, my own research has identified this is a weak area, and an area I would invite any of you to get in touch with me if you want to explore further how we can better understand the health risks or the health effects of the risks arising out of work. Zoe, any thoughts?
Bit of a big question, really, isn't it, for 2 minutes?
That's why I kept it short, because I can't take it in the time we've got.
No, I think we need another session on that one. But yeah, I mean, very, very good question, obviously, but incredibly difficult to give a kind of helpful soundbite on that one. It's a really, really complicated issue. And I think, to be honest, that's why everyone still has a habit of focusing on safety, not health. But actually, people tend to break a leg and come back to work in 6 weeks.
I know.
A bad back, 6 months or 6 years. It's much, much more debilitating, actually, having a health impact. But I don't think we look at that enough. That's
right. 2 left to do, so we're getting through. Terence, again, psychosocial absences. How would an employer be reasonably expected to judge whether an employee's absence due to stress that results in over 7-day incapacitation to report under RIDDOR? I'm struggling with that one a little bit. So how would an employer be reasonably expected to judge whether an employee's absence due to stress that results in over 7-day incapacitation to report under RIDDOR?
Yeah, I'd have to go back actually and have a look at RIDDOR, which is my least favourite piece of law, because it's so woolly and badly drafted, as to whether any, even if you felt that there was a causal connection, I think that's what the question's getting at. If you feel there's a causal connection between somebody's work, their ill health, and then being off for over 7 days, I'm not even sure that's RIDDOR reportable as an over 7-dayer, but I might be wrong. I'd have to go and look at the law. I think the question is rooted in the difficulty of this issue, which is, of course, I would agree that there are so many potential causes of somebody's psychological ill health that it will be very difficult to say it's all work or it's mainly work. It is a very, very complex and multifaceted area. Work clearly has a part to play in somebody's mental health, and we can only control what we can control, which is the work, the business, and the factors that we put in place and what we expect people to do. Whether somebody is also psychologically ill because of the way they were brought up or because of the relationship with their wife, the husband, or they've got a predisposition to it, is not a matter for the employer in my mind. And that's why I don't think we'll see much enforcement. I think what we're going to see is the HSE starting to just ask more questions about how, as an employer, do you even recognise that your work could have an impact on somebody's mental health? What policies and procedures and support have you put in place? That's not to say that when somebody falls ill, there is a direct causal connection between that illness and the work. That's much, much too difficult. But from a foreseeability perspective, the HSE will want to see that you recognise the risk and that you're trying to manage it sensibly. That's where I think the HSE will be coming from anyway.
Grant makes a comment, HSE sees stress as a state rather than an illness, as I understand it. I think we need to, stress at work and how that develops, I think we need to look at it further, because, I mean, but HSE always has, there's no such issue as stress, because that's why it's management standards. And I think the key thing is for defence is to look at the management standards and understand how they work. But there's a piece of research done by myself, Andrew Sharman, and David Gold, all looking at different types of stress using the SOLVE methodology, and that's available. I think if you put Thomas, Gold, and Sharman, a paper will come up in Google Scholar. Okay. The last question is, Andrew, you asked a copy of the slides. The webinar will be published. The webinar will be live, and you can see everything on the webinar. We could put up this slide somewhere, couldn't we, as well? So you're happy with that? Yeah. Melanie mentioned, I understand, not only physical but emotional injuries reportable as employed for 7 days absence.
I'm sure that's right.
Again, but we have to look at RIDDOR. We've got 2 minutes left. The last question from Christopher. The AI technology is good, but would it not endanger? So Anthony's saying stress at work is reportable under RIDDOR. Thank you. But I will still always read RIDDOR. I always used to read RIDDOR rather than memorise it. Read it when something happened to double check it on the day. Is it up to date? It's a coward's answer, I know, Anthony, but and RIDDOR is because it's more than accidents and ill health. It's also, of course, dangerous occurrences and also things around gas, isn't it? And things in terms of which I came across of providing advice and assistance to
Yeah.
a housing association. The AI technology is good, but would it not engage with the SAG workforce in the future? Instead of human beings, it replaced with robotics to scan the site. I mean, robotics have got a place to play. The issue for me is robotics and engineering and actually maintaining and looking after them. Can you actually control robotics? You know, we have got the universal soldier already. It's said that China does have robot soldiers that are bigger and stronger than the human being. You know, there are and what do we mean by robotics and that? It's a bit dodgy, isn't it, Zoe, where we go with the world of work on this?
Yeah, again, it's hard to sort of do this justice in the time that's allowed. But for me, everything always comes back to risk assessment, because you've got to make sure that you're not reducing one risk, but replacing it with another. And we have seen incidents where robotics and humans trying to interface together is quite a bad idea. And where the risk profile changes, and this is what I think some businesses don't keep pace with very often, they will introduce some new technology for all the right reasons, but actually forget to go back to basics and figure out, well, how are we going to use this? How will this interface with the other risks within our workplace? And are we happy with that? And what do we need to do differently? So I think robotics has a place, but they're not risk-free, and nobody should think that they're risk-free. So yeah, ultimately, I think we'll be moving towards more AI and more robotics in the future, but just you cannot get away from the fundamental health and safety principles that we're all familiar with.
So that is brilliant. Thank you very much indeed. We are at 14:30. I'm going to go by 30 seconds. You mentioned competent advisors earlier on. I always remind my students that there's no such role as a competent advisor. It's competent assistants. And that's the key thing. And that is the word we have to be using. We are profession of assistance, and we do advice is part of that assistance. And if we're not listened to, of course, then then we are into this this section 36. If we've given emails, that's why I always used to say that if I'm an in-house health and safety professional, am I the HSE's prosecution? Am I the key person? Because I will save my emails. I always said I will use my emails. Was never a threat, it was a promise, because I'm here because if I have got my professionalism to consider as well as the people that, we're into this because we care about people. That's my personal thought. So that's my final piece there. Been brilliant, Zoe. I hope we can do this again some other time. We got up to 190. Brilliant. Anybody else here wants to present or anything, or do anything, have any topic you're interested in, please email me, contact me through the IOSH page, or look at LinkedIn, or look at my personal LinkedIn. Zoe, thanks again. Take care. And behind the scenes, thanks very much to our team back at IOSH as well for making this happen. Take care.